You're listening to the Patenting for Inventors podcast with registered patent attorney, Dr. Adam Diamond, founder of Diamond Patent Law, the #1 source for securing your intellectual property needs. Now, here's your host, Adam Diamond.
Hello and welcome to the Patenting for Inventors podcast, episode 59. Do I need to file a continuation in part patent application? My name is Dr. Adam Diamond, a registered patent attorney and founder and owner of Diamond Patent Law in Los Angeles, California. I can be contacted through my website at diamondpatentlaw.com. That's DIAMENT, patentlaw.com. Or if it's too hard to remember, you can get to it through patentingforinventors.com. That's patentingforinventors.com. Or call me at 424-281-0162. And while most attorneys can only practice in states where they're members of that state's bar, patent attorneys are actually allowed to practice patent law in any state, so feel free to contact me regardless of where you live. In the last 3 episodes, we're talking about continuing patent applications. The first one was a general overview, the second one was about divisional applications, and the last episode was about continuation applications. This episode is about continuation in part applications, also called CIPs. So let's go back to the example I used in the last episode about the carrot peeler. In the carrot peeler example, you can't have claims to things or new variations that weren't discussed in your original application. If you have new variations that weren't discussed in the original application, you can't file a divisional or a continuation. You have to file what's called a continuation in part, or just a brand new application that doesn't claim priority to anything, but just has new variations. Now, they're called continuation in part applications because in some ways they are a continuation application, since you're generally claiming an invention that continues or is somehow related to your first application. But it's not just a continuation. It's also partly new because you're adding new subject matter, so it's a continuation in part. So what is this useful for? Let's say you came up with the handle and vibrating blade for your application. A year later, you think of this really new cool feature about the sound wave generator. You didn't discuss the sound wave generator in your first application, so it's not like you can just write claims that include a sound wave generator, because that's not in your application. What you do is you write a brand new application, and you pretty much just duplicate everything your first application had. But in the description section, now you add a description of the sound wave generator, and you add in any illustrations of this new sound wave generator, and you can write in the claims parts related to your sound wave generator as it relates to the peeler. Now, for the cross-reference to related applications, you would write something like, this application is a continuation of part of U.S. application number, and then you put in the application number of your original application, filed on, and then you put in the date. So what do you do with the first application that didn't include the sound wave generator? You can abandon it, or you might just want to see how it goes and see if you get a patent for the first application, and then get a patent for the second application that has the sound generator as well. Now, practically speaking, though, in this case, you probably would abandon the first application, and you can write broad claims in the continuation in part that don't include the sound wave generator, and then other claims that do include it. These are strategies that you should be discussing with your patent attorney, and if you're actually at the stage of filing continuation applications, then you probably shouldn't be doing it yourself because it can get a little messy, and you don't want to mess up on this kind of stuff. There are a few things that are different about continuation in part applications compared to the other ones that I talked about. And one is that you only get the benefit of priority for the things that were in your original application, not for the new things that you added. So if you filed your original application on January 1st, 2018 with the handle and vibrating blade, and then on January 1st, 2019, you filed a continuation in part application with the sound wave generator, if you're just claiming the handle and vibrating blade, also in your second application, the examiner can't cite prior art that happened prior to January 1st, 2018. But if you're also claiming things that have to do with the sound generator, the examiner can cite prior art that occurred between January 1st, 2018 and the new filing date of January 1st, 2019. So it can get a little tricky. Also remember, and this is very important, is that the term of your patent is calculated as 20 years from the filing date of your earliest filed application, even for a continuation in part. So if you filed your first application on January 1st, 2018, and then you filed your continuation in part on January 1st, 2019, and you get a patent on your continuation in part, it's going to last until January 1st, 2038, which is 20 years from your original filing date, and 19 years from your continuation in part application date. If you had just filed a separate new application with the sound generator without claiming priority to anything, your patent would end January 1st, 2039, a full year later, because you don't have an original application that you're claiming priority to. I know I'm throwing out all these dates and numbers, but it is important, and it's something that you need to discuss with your attorney because you need to think about what all this means. Now, since a continuation in part doesn't get the benefit of priority for that new application for all the new stuff that you're adding, so it's not like you're getting a big advantage of being able to exclude prior art. And if it issues, you get dinged because you don't get a full 20 years from the filing of your continuation in part application. You only get 20 years from the filing of your first application. So what's the point of a continuation in part if your patent term is essentially shortened and you don't get the benefit of excluding prior art? This is one of the reasons why I think continuation in part applications are really overused most of the time. And when you think you might want to file a continuation in part, you really should just be filing a new application and not claim priority to anything. Now, if you want to understand more about this, you should Google an article called "To CIP or Not to CIP, There Is No Question." And the authors make a really good case that it's really only in rare circumstances that a continuation in part application is actually appropriate. Another reason why CIPs aren't that great is that your own original application can be used against you a lot of times. Now, how can your own application be used against you? Remember, as a general rule, anything known by the public can be used against your application before your application filing date. Now, there is a 1-year grace period, so if you disclose something, your own invention, you have 1 year to file a patent application or you're out of luck. It's just in the public domain. So this is how it can happen. You file your first application on January 1st, 2018. 18 months later, your patent application publishes. And this is generally what happens, and it would happen on July 1st, 2019. Now, because your first application is now public, you only have 12 months until your own application can serve as prior art against anything else that you file. So 12 months after that is July 1st, 2020. Now, if you file a continuation in part after July 1st, 2020, your own application can be used to show that your new versions were just obvious modifications of your original application. Now, maybe you're asking, okay, well, if I file a new application after July 1st, 2020, my own application can be used against me too. And that is true. But let's say that you're able to overcome the obviousness rejection. You convince the examiner that your sound wave generator is not obvious over your handle and vibrating blade carrot peeler. If you filed a continuation in part, that application would only last until 2038, 20 years from the priority date. But if you filed a new application instead of a CIP, then that application would last 20 years from your 2020 filing date. So it would finish in 2040. So I can't think of any positive aspect of filing a continuation in part application if it's more than a year after the publication of your original application, which generally is about 2.5 years after your initial filing. You may as well just file a new application because your original application can be used against you no matter what, and you're just shortening the length of your patent if you do get one. Even if it's not 2.5 years after filing, most of the time, the possible minor benefit of a continuation in part isn't worth losing the length of your patent. There might be some interesting scenarios where a CIP is the best strategy, but that's something that you and your patent attorney should discuss with you, because most of the time it's actually not the right choice. I do it sometimes for particular situations where it is the best strategy, but most of the times a new application is the best strategy if you're adding on variations to your application. In the introduction episode where I talked about the different types of continuing applications, I did discuss 2 others. I talked about reissue applications, and for design patents, a continued prosecution application. Now, these are a little bit more specific, and I'm going to hold off and not do those right away because I'd like to discuss some other things before going into those pretty technical and tricky details having to do with those. Now, if you want help with your patent application, you can contact me through my website at patentingforinventors.com. That's patentingforinventors.com, or call Diamond Patent Law at 424-281-0162. I'm Adam Diamond, and until next time, keep on inventing.
Thanks for listening to the Patenting for Inventors podcast with host Adam Diamond. If you enjoyed the show, please rate and review on iTunes. The contents of this podcast are intended for general informational purposes only. The facts of every legal matter are unique, and the content of this podcast should not be construed as offering legal advice for your specific legal situation. For more information and help with your own intellectual property needs, contact Adam Diamond at patentingforinventors.com. That's patentingforinventors.com. Or call Diamond Patent Law at 424-281-0162. The preceding information may be considered an attorney advertisement and does not establish any attorney-client relationship.